First steps. When faced with a safeguarding allegation, what are the first steps to be taken? Swift action is required. Don't delay. Report the allegation to the local authority designated officer, LADO, immediately. Do not investigate the allegation at all until LADO has given you authority to do so. At this stage, do not alert the accused. With safeguarding investigations, you do not alert the accused until LADO and/or the police, if they become involved, tell you to. There can therefore be some delay between the initial concern being reported to you and you starting your investigation. Assuming you have authority to investigate from LADO, what are the initial steps involved in your investigation? Confidentiality. Keep the allegations on a need-to-know basis and ensure that those who do know maintain the confidentiality of not only the allegations but also of the fact of the investigation. Identify your investigator. Experience of disciplinary investigations and/or safeguarding is desirable. You will also need a second and third person for a disciplinary hearing and potential appeal if the case goes this far, so don't use up all your senior management team at this stage. And identify your witnesses. How do you identify your witnesses? This is going to be a judgment call for the investigator. Some witnesses will be obvious because they either came forward to report the incident or have been identified by the complainant as a witness. Some witnesses will not be obvious, and the investigator may have to press the complainant for details of witnesses. Sometimes an investigator may be pointed in the direction of multiple witnesses or potential witnesses. It is not the investigator's job to hunt down every possible witness to the incident or to necessarily investigate every witness identified in the case. The investigator should consider who has identified those witnesses and whether the lead was credible. Was the identifier of that witness certain that that person witnessed something? Alternatively, did they maybe think the other person was present and maybe they saw something? If you choose not to speak to a particular witness, the investigator should minute their reasons for this decision in case of subsequent challenge. Tips for interviewing witnesses. Use open-ended questioning. Let the witness tell you what happened in their own words. Do not lead your witnesses. Take minutes of the interviews. Ensure you have a detailed account of what the witness saw and heard. Ask the witness to sign the minutes to reflect that they are a true and accurate record of the meeting. Once LADO has given you the go-ahead, you can interview the accused. In the interview, you should ensure that you state the detail of the complaint. You may be limited as to how much detail you can give the accused in the early stages, so again, be guided by LADO. Give the accused an opportunity to respond, to state their case. On the basis of the complaint and the nature of the accused, consider whether suspension is necessary, but do not rush to suspend. Get the accused to sign the minutes of the meeting as a true and accurate record. Also, when interviewing the accused, you should give them the right to be accompanied. Safeguarding allegations are extremely serious, and the accused should have the opportunity for support in discussions about the allegations. The right remains to a colleague or a trade union representative, though it does not extend to a legal representative. Disclose copies of the evidence against the accused. It is advisable to invite them to the meeting in writing. Outline the case that the accused has to answer, and don't forget to ask them to sign the minutes. As noted before, one option in dealing with the accused during the investigation is to suspend. However, there are very significant risks in suspending of breach of contract, unfair or constructive dismissal, and in discriminating against the accused. To minimise these risks of suspension, schools should therefore only suspend having carried out a preliminary investigation, including hearing the accused's version of events. Having undertaken a suspension risk assessment. What are you trying to achieve by suspending? what is likely to happen if you don't suspend. If you do suspend, this needs to be on full pay, and the accused should be offered reasonable support, including emotional and psychological support. This is where your employee assistance program will come into play. If suspended, the accused should be given a named contact in the school with whom they can keep in touch and direct any queries about the terms of their suspension or to access the support previously mentioned. Having carried out a preliminary investigation, you are likely to have further questions. Further investigations should therefore be used to 1. Clarify facts, 2. Address any inconsistencies in the story, 3. Check the evidence to ensure it is sound and stands up to scrutiny, 4. To identify any further questions that need to be investigated and/or put to the accused. Once the investigator is satisfied that the investigation is complete, their findings should be set out in an investigation report. The report should outline 1. The details of the allegation, 2. The investigation conducted, 3. Any points of disagreement or dispute between the versions of events, the investigator's recommendations for further action, 5. Copies of the witness statement should be attached, and 6. Details and copies of any other evidence collected should be listed and included. The final report should then be disclosed to the accused. Has the investigator decided that there is a case to answer? Has the investigator concluded that there is sufficient evidence to support the allegation and/or a charge of gross misconduct? If so, the accused can now be brought into a disciplinary hearing. There must be a formal invite to the disciplinary hearing, and the accused has the right to be accompanied by a colleague or a trade union representative to the hearing. So who attends the disciplinary hearing? From the employee's side, the accused will be there, together with their companion and/or trade union representative. From the school's side, you will have the disciplining officer and/or the panel, together with a minute taker. There is no need, and it is often inappropriate, to have all the witnesses present at the disciplinary hearing, particularly if you have disclosed witness statements. Who should conduct the disciplinary hearing? As already noted, this should be somebody other than the investigator. So 1. Check your contracts of employment and/or disciplinary procedure to see what they say about the identity of the disciplinary officer or panel. 2. Ensure that whoever hears the case is not biased. 3. Consider who would hear the appeal. Ensure you have sufficient people left to independently investigate the appeal. Once you're in the disciplinary hearing, what should you be doing? 1. Show that you have an open mind as to the allegations. If the accused presents new evidence, follow where that leads and undertake further investigation if necessary. 2. Provide clarity. Make sure that the allegations are appropriately drafted so that both the accused and the disciplinary officer or panel know what they are discussing. 3. Ask questions based on the evidence and allegations. And 4. Give the accused the chance to respond. He or she can ask questions, they can put forward their own evidence, and can challenge the evidence that you have collected. When deciding the outcome, ensure you consider the evidence in detail. Be a conscientious investigator. Pursue all reasonable lines of inquiry and do so in good faith and with an inquiring mind. Once you have made a decision, explain it on the basis of the evidence and the investigation conducted. Make sure that you genuinely believe in the decision that you have reached. The outcome should then be communicated in writing. You need to explain 1. How the allegation came to light, 2. The investigation that was undertaken and the evidence collected, 3. Details of any evidence corroborating the allegation, 4. Your thoughts on any discrepancies thrown up by the investigation and whether you have taken them into account or disregarded them. 5. Address any inconsistencies in the witness statements and how they have factored into your decision. 6. Take account of the history of both the accused and the witnesses. Does the accused have an exemplary disciplinary record? Have the witnesses ever been in trouble before? If so, is that trouble relevant? Do they have a history of making up false allegations, etc.? 7. Consider alternatives to dismissal. Why does it have to be dismissal? What are the risks if you don't dismiss and go for a final written warning instead? Show you have properly thought about the appropriateness of the outcome. Appeals are important. They give the school the opportunity to rectify any procedural errors or to address any questions that were left outstanding at disciplinary. From the accused's perspective, it is an opportunity to bring up points that they may have forgotten during the disciplinary hearing. What's involved in an appeal? First, the accused needs to submit their grounds of appeal. What specifically about the decision is the accused challenging? 2. Who is going to be involved in the appeal? Do you know the identity of your appeal officer and/or panel? Or do you still have to decide the makeup of the panel? 3. Set a reasonable timescale for hearing the appeal. What is the appeal officer's panel's availability? Is it limited in any way, for example by holidays? 4. Redress any errors of procedure, for example disclose any evidence that was not previously disclosed. 5. Look for any further evidence one way or another. If the accused wants you to consider a new witness, do so. In summary, what do we need to remember in conducting a safeguarding disciplinary hearing? 1. Ensure you follow a fair process. Follow the ACAS Code of Practice. 2. Keep all documentation and make sure you document all steps taken and decisions made. 3. Choose the right people for the job of investigating, disciplining, and hearing an appeal. 4. Give due consideration to the evidence. Make your decision off the back of the evidence. If you have any further questions or want to find out more about our services, please do get in touch. You can email us at enquiries@elliswhittam.com or call on 0845 226 8393 or find us online at elliswhittam.com or on Twitter, Facebook or LinkedIn. Thank you.